Hi, Robert Eckert, your board-certified business litigation attorney and government investigation specialist. Today I'm going to speak to you about 10 personal qualities you should look for in retaining an expert witness. When attorneys look to hire an expert witness for their case, they look at certain qualities that they believe will result in a win for their clients. In any area of the law, the quality of the expert witness can range from excellent to very poor. Additionally, attorneys can spend thousands of dollars for an expert opinion that they need to prove their case, but while obvious qualifications such as expert's education, skills, and work experience are reliable, objective indicators of an expert's suitability for a case, there are a number of intangible personal qualities that are equally important to consider. This is why attorneys need to look for the following list of traits in expert witnesses to make sure that they have an expert whose opinion will be believed by the judge or the jury. Number one, you want your expert to have confidence. Confidence matters. Expert witnesses are subject to depositions and are often cross-examined by opposing counsel regarding how they came to their conclusion or opinion. Expert witnesses may have to testify in front of a judge or jury, and their opinion needs to be believed by people who are not familiar with their area of specialty. A confident expert sends a message that they believe in their opinion, and that means that the judge or jury will as well. An expert who is not as confident about their opinion can send a wrong message to the judge or jury that there's reason to doubt their opinion and what they're saying, which may cause them to look to the other side's expert. Number two, rigor. Expert witnesses need to have scientific or specialized knowledge that is the basis for their opinion. Many times an expert will say that they base their opinion on their years of experience. However, if you're dealing with a scientific or medical opinion, a dauber objection could potentially be raised if they have no peer reviews or research journals used to support that opinion. In hiring the expert witness, you should ask what type of research have they looked at or relied upon in forming their opinion, or if their methods are also used by other members of their specialty. Three, you want consistency. An expert's opinion is delivered primarily in three stages. First, you have the time where the expert prepares their expert report, documenting their findings and methodology they used to obtain them. Second, there is the deposition where the expert testifies regarding their opinion and is cross-examined by opposing counsel. And third, you have when the expert is testifying in front of the judge or jury. Many expert witnesses testify in multiple cases, and they may not remember everything that they've said in their reports or in their depositions. And this can cause inconsistencies which can be pointed out by the opposing party in order to diminish the opinion of your expert. This is why it's important that your expert be consistent throughout the entire process of preparing a report, their deposition, and testifying at trial. Consistency also matters from case to case. Let's say an expert gives an opinion on the causes of heart disease in one case where he says that smoking does not cause heart disease. Then, let's say he gives a second opinion where he says that smoking can cause heart disease. Let us further assume that we're in a county where the law firms talk to each other and exchange transcripts of depositions between cases. This opens to the possibility of your expert witness's opinion being impeached by these inconsistent opinions in a prior case. Number four, attention to detail. In litigation, details matter. Whether you're looking at a long list of medical records or a compilation of complex engineering schematics or patents, expert witnesses need to have a high level of attention to detail. The failure to exercise high attention to detail can result in the expert being crushed on cross-examination for failure to take the proper time to examine the facts before rendering their opinion. One of the most common ways to undercut the opinion of an expert witness is to point out all the things that were not done or not reviewed in rendering their opinion. Number five, trustworthiness. Expert witnesses need to convince others that their opinions can be relied upon. Trustworthiness begins with appearance. Expert witnesses should be properly and professionally dressed for their appearance in court or at the deposition. Expert witnesses should speak with confidence and should be attentive when rendering their opinions. Trustworthiness also means that they are not willing to ignore facts that are unfavorable to them or the side that hired them. Reputation matters when we are speaking about trustworthiness, and experts should avoid rendering ill-informed opinions that could damage their credibility. Number six, All expert witnesses should have a detailed curriculum vitae that outlines their educational background as well as any licenses, publications, speaking events, and honors that the expert received. Expert witnesses should have top-level educational credentials and should have staunched the level of experience in the area that they're rendering an expert opinion on. While relevant professional experience is always a requirement in an effective expert, additional experience with public speaking, teaching, or other interpersonal activities can indicate that a potential expert will likely be a strong choice in a testifying role. Number 7, effective communication. Expert witnesses need to be good communicators. This means that they have to be comfortable using the technical language that is common within the profession. They should be able to speak without hesitation or needing to refer through the records in order to render their opinion. Good experts need to be capable of understanding the questions that are being posed to them by the attorneys and specifically answer the question asked. An expert who is a good communicator can summarize complex scientific, medical, or specialized facts in a concise way which allows the judge or jury to understand what they're saying. Number 8, dedication. One of the most important functions of an expert witness is the preparation of a detailed written report of their opinion. The expert report should compile all records that were reviewed in order to render the opinion and outline a concise summary of their findings and recommendations. Good experts will often ask you to send them records because they believe they need to review additional information to properly support their opinion. One of the techniques attorneys use in trying to diminish the opinion of an expert is pointing out things that they are testifying in deposition to which are not contained in their expert report. The expert report should be free of typographical errors and should have a proper chronology or a list of all relevant facts that were reviewed to come to their opinion. Good expert reports also cite the relevant authorities in peer-reviewed journals or other sources to bolster their testimony. Number 9, ability to improvise. Good expert witnesses need to be able to improvise. One of the most important times in litigation is when an expert is asked a question that they're not prepared to answer. Knowledgeable experts need to be able to come up with answers to complex hypotheticals on the spot. A common trick that attorneys use in order to diminish the opinion of the expert witness is to get them to say, "I don't know," number of questions. Expert witnesses should be able to think on their feet based on their training to answer those questions they didn't anticipate. However, they should always be careful to only answer questions that fall within their specific area of expertise. Number 10, overall positive appearance. Trustworthiness begins with appearance. Expert witnesses should be properly and professionally dressed for their appearance in the court or at a deposition. Expert witnesses should speak with confidence and should be attentive when rendering their opinion. Courtroom attire might seem low on the expert's priority list, but what a witness wears does have an effect, both positive and negative, on a jury. While the typical attorney uniform of a suit and tie is ubiquitous in the courtroom, an expert's choice of clothing is more nuanced. Because expert witnesses have more leeway in what they can wear, that freedom should be exercised strategically. If what an expert wears can have even the slightest positive impact on a jury perception, it is a topic worth considering. The expert's attire also sets nonverbal cues as to credibility. Therefore, the main goal for an expert's ensemble is that it is an accurate reflection of the professional area of their expertise. While traditional business attire and business casual wear are safe and professional choices, sometimes neither will precisely convey the expert's message. If there's a style of dress that's frequently associated with the expert's profession and is still considered generally professional enough to wear in court, then the expert should consider that attire. As always, if you have further questions or information that you would like from our firm, please feel free to contact me at 727-772-1941. Thank you.